was trying to wait for the train to pass. Hi, Ava. Oh, hi, good girl. Okay, I'm lying. She's been naughty. But she's still a good girl. Hi, Snitch. Get off the keyboard before you start actually doing things on it. Yes, hi, baby. I transferred the Blue Buffalo treats into this cat treat container. Yeah, I couldn't take the cats trying to get into them anymore. So I alleviated that problem. All right. Time to grace the kitty cat tower with tons of treats. Got a whole drawer of treats that they've fallen all over into. All right, guys. You ready? Oh, I know. I hear you, Earl. There. Now I can give them treats. Now I can give them treats. Look at you, Earl. You're just waiting. Here, let me move this toy back down to the floor. You missed the ones in here, dude. You didn't even try. Here, you've been begging me since like 9:30. You could have come up here and had them all for yourself. Billy, knock that down. Trying to more precisely, calculatedly throw them, and I'm not doing very well at it. Smaller handfuls, and they're just going everywhere. I'm not good at this game. My hair's still a little wet from my shower. I went to put on one of my shirts that I love, right? So this one here that has the open shoulder, but it also has, where this hangs down, that, it drapes down the arm. So I went to put that on, and I found that I might give everybody a surprise. So I got the sewing kit out. Yeah, I'm gonna be mending that. It was much tinier the last time I saw it. So oh, it didn't necessarily rip. It just, it just kind of came apart at the seam, which, they do that in the wash sometimes when they get twisty. So hello, Jerry Matthew Boyd. I know you see me tonight. Hello, Buzzy Pug. Hello, Nana Laura. Hello, Wire Mother. Hello, Eileen and Carlin. Hello, Hello, Charlie. Don't forget to hit the like button before you doze off to dreamland, and then you have many sweet dreams about me. You can dream that I flew to Tennessee and we went out for coffee and then we raised all kinds of heck in your town. and by heck I mean, did almost absolutely nothing. We just told jokes and cut it up for a while. Ooh, I forgot I just made that. That was a bit warm. Hello, C-Rex. Hello, Spider-Man. Hello, Mike. Thank you so much for being here. We love our lurkers. Hello, Mark Addy. Let's see here. Hello, Linda Adams. Honey, you are too sweet to me. Grease. That's why I can't eat them. That's what it feels like. I'll take chocolate-coated bacon over chocolate-coated pork rinds anytime. But I much prefer brown sugar bacon. Yeah, that's actually pretty darn good stuff. You'll pick me up at the airport. The three of us will have a grand old time. 28 months. Oh my goodness. Has it been worth it, Mom? Oh my goodness. We got Eileen singing MASH songs. You forgot the asterisks. All right. Man, you kitties are messy. Guys leaving all kinds of crumbs all over my desk and fur and you name it. Probably are the reason my shirt got a hole in it too. I bet it happened from kitty claws. All right. So we have some good court stuff. And it's not the 2-hour Ricky docket that I had made. But yeah, I wasn't sure if I was going to get the thumbnail up in time because I ran out of words. I ran out of space on my computer and I had to move stuff around because, like I mentioned before, my G drive is full. And so my C drive was full today. And so I had to put stuff on the F drive. And now it's looking okay. I've got a little time. I've got a little time to order another drive. I'm gonna have to because I've only got about 2.5 terabytes free, and I go through that in less than a month now. Now that the files are bigger, since I can't use my program that gives me small files anymore. No, I take good care of it. It's Alienware has a very good built-in cleaner system. So I do have to run that. I haven't run that in a while, but it tests all
of the, like, it tests everything. Like, all of a sudden you hear like the loudest whirring in your life and you think your computer is going to take off like a helicopter. Yeah, it does that. And then it calms down and it says everything's okay. Nana Laura, this is like the third train in 15 minutes. So I hope they're all coming your way. It's so good to see you. I hope you're wearing your PAWFURM shirt. Hello, sweetie. How you doing, Squishy? You just gotta turn on the charm with the new CNAs. Those are the ones that you can get to powder your tushy. Yep, your squishy tushy. Yep. Pick the shyest looking CNA and just be like, when I was in the hospital, they were putting cream on my bum and powder, and it really helped. And do you have any of that available? And act like you plan on doing it yourself, and then they'll do it for you. Oh goodness. Well, they can still haul their little cabooses to you. I bet it was the Amtrak train coming through and letting passengers off, and then that backed up the commercial trains or whatever they're called. All right, so you're at a facility, but at the start of therapy. Ooh. Well, that just means they're working on strengthening you to get you back home. That's good news. A powdered, pampered bum or not. I was that shy little CNA when I was in my clinicals. Yeah, I had to powder a few old people's bottoms. We're just glad you're okay. I do. I have I have 3 SDDs and 2 HDDs, I think. I've got a lot. I've got a lot of space. I prefer the SDDs, but do you know how expensive they are? They're like half the cost of what I paid for my entire computer. SDDs are expensive. So getting an 8 terabyte SDD is right now is like, I think it was like $1,500. Yeah, it's expensive. Oh my! I would be asleep on the train when it pulled up to its destination, and I'd end up going somewhere else. They'd call for me to get off, and I'd be like, where am I? In Boston. How did I get from California to Boston? SDD, squishy. No. Solid state drive is SDD. I didn't think I would have to clarify, but then I forgot Squishy was here. If Mortimer Duke was here, it probably would have been just as bad. All right. So let's see. We've got Rogers, Hesselink, Blanchett, and Ricky. Yes. Yes, we do.
Hadley Elizabeth Scheffler.
Thank you, Ms. Scheffler. My name is Judge Hesselink. I'm coming to you from the district court. My job today is to arraign you. That means I'm going to tell you what you're charged with, tell you what your rights are, and then we'll address the issue of bond. So listen carefully as I read the charge to you. It says that on or about June 25th of 2026 in Bagley Township of Otsego County, that you did commit the offense of domestic violence, meaning that you did assault and batter Christine Scheffler, a resident or former resident of your household, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 93 days and or a $500 fine. Do you understand the name of the charge that's been made against you?
Yes, sir.
Do you understand the maximum possible penalty of that charge?
Yes, sir.
Your rights as to that charge include the following. You have the right to plead guilty, not guilty, or to stand mute. You have the right to have a trial before a judge or a jury, and you have the right to an attorney. And if you cannot afford an attorney, one may be appointed for you. We'll talk about your attorney in just a minute, but I want to explain your trial rights first. If you wanted to have a trial, as I said, you could have that trial in front of a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to have your attorney or an attorney represent you at that trial. You could present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could testify, or you could choose to remain silent. And if you remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. But if in the future you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just explained to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
All right. Mr. Brown, have you discussed the matter of an attorney with Ms. Scheffler?
I have, Your Honor. She would qualify. I did forward that information, and one will be appointed.
All right. Ms. Scheffler, that appointment of an attorney is going to take just a little bit of time to process. We'll get that attorney to you as quickly as possible. In the meantime, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set what's called a pretrial conference that will allow your attorney to speak with the prosecutor's office to try to quickly resolve the case, and they will do that as quickly as they can. Right now, we're going to turn our attention to the issue of bond, and that's under the circumstances under which you could be released from jail. And what I'm going to do is I'm going to listen to both of the attorneys, tell me what their recommendations are, and then if you have anything else that you want to tell me after that, I'll listen to you before I decide what to do. Ms. Brucker, your thoughts?
I would just note for the court that the alleged victim in this case is her mother, and she's also present here on the Zoom. Defendant does not have a criminal history. I would be requesting the standard terms of bond, that she attend each and every court hearing, that she not leave the state without permission. I'd also request that she not commit any additional crimes while on release and not display any assaultive behavior while on release. I would ask for her to not have contact with the victim in this case, and it's my understanding that her mother is going to agree to leave the home so that defendant can go back to the family home. And I would just be requesting a $2,000 PR bond.
All right, thank you. Mr. Brown, your comments?
Your Honor, I would agree with the PR bond in this particular case. She does live locally here. She's only 21 years old. She has no prior criminal history whatsoever. And she's definitely, in my opinion at least, given that this is a parent-child that is involved here, so I don't think she's any threat to the community at large. I guess I am unaware of who lives in the home, whether or not Ms. Scheffler would want to return to that home. She was advising she doesn't have any place else to go. She'd be going to a homeless shelter. So we're going to have to maybe inquire of her because that'll obviously be up to her. But She is aware of the no contact order. She does agree to abide by any rules that the court lays down.
If my daughter ended up assaulting me, there is no way that I would leave my home for her to have full access to it. No, that's not going to happen. How do you think you raised that spoiled little brat that you have that has the audacity to attack you?
But if she, for whatever reason, would stay at a homeless shelter, that may cause some notice issues. So I will let the court address that with her.
Thank you, Mr. Brown. Ms. Scheffler, in a moment, I'm going to give you an opportunity to say whatever you want as well. I simply want to caution you not to make any statements about the facts of the case, because we are recording this and it might be used against you later. However, if you have some information that you think I need to be aware of about this, the stuff concerning bond, which is where you're going to stay, where you work, how to get in contact with you from the court to make sure that you make your appearances, I'd be happy to hear anything like that. Go ahead, ma'am.
I don't know of anything specifically like that right now. I am without a vehicle, and not to go over any facts, but it's very obvious that's what the argument was over. So
Well, Ms. Scheffler, you don't want to talk about anything that has to do with the case.
I'm not trying to reference anything in the case. I'm just trying to ask the questions that I need asked, like, because I just have a lot of questions, I guess. I've never been through this process, and I'm not sure even I just am looking for a little direction of what I can even ask, or what I should ask you, I guess.
All right, well, let me try to help you a little bit. The prosecutor has recommended what's called a PR bond. It means personal recognizance. That simply means that you'd be released without having to pay any money from the jail. And I would impose some conditions on you. And one of those normal conditions is that you have no contact with the alleged victim. I understand that to be your mom. That may form a hardship for you because I believe, correct me if I'm wrong, but I believe you live in the same home as your mom. So
Yes.
The prosecutor told me that your mother is willing to move out so that you can go into the home that you've been staying in.
Yes, but I know she has nowhere to go, so I know logistically, that's probably not going to happen if you want my opinion on it, but that's just,
All right. So
I don't even want to say that.
And that's fine. So here's the deal. I can't make your mom move out. I don't have any authority to do that. I can say that I do have, because I have authority over you because of these charges, I can say that you can't have any contact with her. In fact, I'm going to. How that works out is probably going to be up to your mom. If your mom wants to stay at the house, then you're going to have to go someplace else. If your mom leaves, you can stay there. On the other hand, if your mom wants to come back, you're back in the same boat. You're the one who can't have contact with her. If I were, and I'm not your attorney, so I can't tell you what to do, I would make sure, if I were in your shoes, that I had someplace else to go. And then I would tell the court where to send that to. So if there's anybody, if you have any friends or any family, or if you can get a motel for a day or two before, so you can figure something like that out, that would be the best thing to do. Again, I don't know what your circumstances are. All I can tell you is that I have control over you and not your mom. So having said that, does that answer some of your questions?
Yes.
Do you have any additional questions?
No. Just about the PR bond, how does that work and what does that look like?
What it looks like is a piece of paper that I will fill out, or my staff will fill out, and I will sign. It will then get taken over to the sheriff's department. You'll be given a copy of it. It'll say what the conditions are so that you know them very specifically. And once that reaches you at the jail staff will process you out. That means that they will take the clothing that you have now and give you back your other clothing and release you today sometime to go about your business. Okay, but you would then be subject to all of those conditions or those rules that I put on you for this bond. Okay, but the bond simply means it's a promise that you will appear at every court date and that you will not violate these conditions that I put on the record. You understand all that?
I do understand. Can I ask another question about my
Yes.
charge? If it's a misdemeanor
Yep.
charge, I doubt it, but am I allowed? Because you said like it's about my living situation. I'm pretty sure the only living situation I have available is out of state. And I don't think I'd be able to go to the living situation I have available with the charge I have on my record at this point. Does that make sense? So I'm unaware of how I'd even.
All right.
Yeah, so-
Where would you be anticipating that you might be living out of state at?
Arizona.
Yeah, that's a really long ways away. The standard rules are that you can't leave the state of Michigan. If there's a specific reason to go temporarily to Arizona, such as you had a pre-planned vacation to Phoenix, for instance, to meet your relatives out there, and you had a date to be there and a date to come back, I often, on a special occasion, will allow that. But just to go out there to live, typically not, because there's little likelihood that you would come back at that point.
So when am I able to go live there? I guess is what I'm asking. In Arizona.
After this case would be resolved.
Your Honor,
So-
if I could just mention, Ms.
Go ahead,
Shepler, we
Mr.
did
Brown.
talk about this a little bit, that I know she's very confused, but she will be appointed an attorney relatively quickly. And these are issues that her attorney will thoroughly explain to her.
It's likely that she has found some man on the internet that lives in Arizona that's telling her how great it would be and no rules and she could do whatever she wanted and he would help her along the way. And this girl needs to be very careful. Let's just say that she could very easily end up putting herself in vulnerable situations if she goes to states she's not familiar with people that she doesn't know.
Thank you, Mr. Brown. I appreciate that. Any other questions that you have right now, ma'am?
No, Your Honor, thank you.
All right. So let me tell you what those specific conditions of your bond are, and then you're going to get a copy of these in writing so that you'll know exactly what they are. You don't have to write them down or try to remember them. I am going to impose a $2,000 personal recognizance bond. That simply means that you do not have to post any money now. However, if you violate any of these conditions, you would then owe the court $2,000. The conditions upon that bond include that you personally appear for any scheduled court date, you abide by any judgment of the court, that you not leave the state of Michigan without the permission of the court, you not commit any crime while on release, you immediately notify the court in writing of any change of address or telephone number. Ms. Brucker, was there any allegation of improper use of alcohol or controlled substances?
No.
Then I'm not going to impose that. You may not harass, intimidate, beat, molest, wound, stalk, threaten, or engage in any other conduct that would place any household member in reasonable fear of bodily injury. That would include anybody that's a resident of your household. Specifically, you may not assault, harass, intimidate, beat, molest, wound, or threaten Christine Scheffler. You may not be within 50 feet of Christine Scheffler or of her residence or place of employment. You are not to enter the residence or her place of employment if she is the resident there. If she leaves, then you may be able to stay there. That is up to her. Do you have any questions about those conditions, ma'am?
No, not about those conditions, no.
Do you have any other questions that I can answer for you?
No, not today, I don't believe.
All right. I'm hopeful that your attorney will get appointed very quickly and that you'll be able to ask any questions that you have of that attorney. We will get this paperwork over to the jail as quickly as possible so that you can be processed out today, ma'am. Thank you. That's all for today. Who do we have at the Otsego County Jail, please?
No, Chris, sir. Your
All
Honor.
right. Let me call your case, Mr. Christ. This is the State of Michigan versus Noel Christ. That's file 26-44637-SM.
Good afternoon, Your Honor. Gabriel Matisse on behalf of Noel Christ, who is participating by Zoom.
Thank you, Mr. Matisse. Looks like we have a bond violation hearing. Is that correct?
Yeah, Judge, we do, but we've worked out a resolution that includes the underlying offense. The prosecutor made an offer that if Mr. Christ pled guilty to the straight up domestic violence in the underlying file, that we would dismiss the bond violation, and that would be the offer on these two matters before the court.
That's correct, Your Honor.
All right. Mr. Christ, you've heard what the lawyers have said. Is that what you want to do?
Yes, sir.
All right. In order to do that, you'd be giving up your right to have a trial and all of the procedural protections that would occur at a trial. Do you understand that?
Yes, sir.
Let me detail those protections to you so that you can make an informed decision. At a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to have your attorney, Mr. Matisse, represent you at that trial. At the trial, you'd have the right to see, hear, and question all the witnesses. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. At a trial, you could choose to testify or you could choose to remain silent. And if you remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir, I do.
Do you have any questions about those rights?
No, sir, not in those general rights, sir. I've got it pretty much understood.
Good. I'm glad to hear that. Have you had sufficient time to talk about this resolution of the case with your attorney?
Pretty much so, sir. We had came up with a couple like little brainstorming of things to work for towards that. And then I don't know what would the right time to talk about them. When maybe after I plead might be the best time.
Yep. That's probably a good time to do that. So let me get through the plea process and then I'll give you a chance to explain anything that you want to explain. Knowing all of those plea rights that you have, is it still your desire to enter a plea today?
Yes, sir.
All right. I'm going to ask you to raise your right hand so I can swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. I sure do, sir.
All right. Put your hand down, sir. Other than this plea agreement, has anybody promised you anything to get you to enter a plea today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you pleading out of your own free choice and free will?
Yes, sir, I am.
All right. The domestic violence charge that's been made against you reads as follows. It says that on or about June the 10th of 2026 in the city of Gaylord, Otsego County, that you did assault and batter Jacqueline Renea McClure, an individual with whom you had a dating relationship. Is that true?
Yes, sir.
All right. And how long have you been dating Ms. McClure?
It was about 2 or 3 weeks before the incident, sir. I had just met her, brought her in my house to help her get on her feet.
All
She
right.
was from up in the peninsula and I was helping to get on my feet, on her feet, sir. That's basically.
And did this incident of domestic violence, did that occur at your house?
Yes, sir. Around the proximity of around my house area, might have been in front or right by the doorstep. Now it's kind of
Okay.
intoxicated, you know. I'm sorry, sir. I was
Yep, that's all right. That's all right. So where's your house located?
Sago Avenue, Kimberly Apartments, apartment 29, sir.
And what did you do that was an assault or an assault and battery to Ms. McClure?
I guess from what she says, I mean, what I was told was I pushed her or something. I pushed her. I really have not too much of a recollection because I was intoxicated very bad. But you know, when I drink, I'm a butthole. I'm not a very good person when I drink, so I can, you know, I don't fend from my drinking at all. You know
Tell
what
me
I'm saying?
what you do remember about this assault. What do you do that made her believe that you were going to hit her or hurt her?
I remember going for my charger. I was trying to get the charger out of the room because I left it at the house, and I think she got in my way, and I kind of pushed her out of the way, pushed her out of my way. I think she was trying to stop me from going out the house from causing, getting in trouble or whatnot because I was intoxicated. And I was coming home to get my charger because that's what I forgot. I was gonna stay out of the house for a few days, but I forgot my charger, so I had to come home. So I
All
guess
right,
she tried to stop me, and I muscled by her, going my charger from my charger,
right.
trying to get out the house, and
Either counsel have any additional factual basis questions?
No, Judge, I think we've established all the elements here.
I agree, Your
All right.
Honor.
Either counsel have any other promises or aware of any other promises, threats, or inducements not stated on the record?
No, Judge.
No, Your Honor.
Both counsel believe I've complied with the court rule?
I do, Your Honor.
Yes, Your Honor.
All right. I do find that Mr. Christ has given me a proper factual basis indicating that he was dating Ms. McClure and that the incident occurred on or about June 10th of 2026 in the city of Gaylord, and that at his residence at the Timberley Motel in the city of Gaylord, he pushed Ms. McClure out of the way while he was intoxicated and drinking. In his language, he muscled by her, trying to get her out of the way so that he could get his charger. Under those circumstances, I can infer an intent to hurt or harm, and I will find that he has given me a proper factual basis and done so knowingly, intelligently, and voluntarily based on his answers to my questions. Let me make my notes here. Ms. Brucker, do we need to have a statement by the victim and then adjourn this matter for sentencing, or how do you want to proceed?
We do, Judge. This was set today for the motion hearing on the bond. So the victim was given notice of the hearing that is the status conference that's set for July 2nd. So if we could just bump this sentencing to July 2nd, I think we could get it taken care of that day.
All right. My staff is telling me that probably will work. Any objection to that, Mr. Matisse?
None here, Judge.
You know, the situation that he's in where he was letting this random woman that he didn't know come stay with him to help her get on her feet. We sure this isn't Arizona?
Oh, there it is. All right, so July 2nd at 9:20 a.m. we'll reconvene, and rather than have it be that type of hearing, we'll use it as the sentencing. So July 2nd.
Your Honor,
9:20. Yes.
I was thinking about is there any way I could be able to get some probation and some anger management and some alcoholic treatment from like AA or NA and maybe public service hours?
All of those sound like great ideas, and I will consider all of those things at the hearing on July the 2nd. The law says that I have to give the victim an opportunity to appear and to make a statement at any sentencing. And because we didn't know that we were going to do a sentencing today, I have to give her notice of that. So to give her a chance to come in if she wants to, or to write a written statement if she wants to. So that's why we're going to wait until July 2nd to bring up those issues that you just talked about. Mr. Matisse, is there anything else that we need to do today?
Judge, Mr. Christ asked me about the possibility of a bond that would allow him to get out. I don't believe he's able to make bond quite right now.
Is there an amount that he believes that he can post?
I believe what he's asking for, because he's become separated from his finances, is some sort of PR bond that would inspire participation.
Ms. Brooker?
Judge, he was originally arraigned and he was given a $3,000 cash or surety 10%. He was then rearrested for a bond violation for consuming alcohol and was a 0.205. And we asked for the bond to be doubled, so it went up to $6,000 cash or surety. I'm a little concerned about a PR bond, given that he violated his bond once, and I know we didn't do a hearing on that, but this is also an alcohol-related offense. So I'd be a little concerned with the court giving him a PR bond.
Mr. Christ, if I let you out, how am I gonna know whether or not you're drinking or not?
Sir, I promise you guys, sir, I won't drink. Your Honor, please, I promise I will not drink. Please. Just give me one chance, please.
You were
I'm
before
sorry.
me. You were before
Sorry.
me a couple of weeks ago, and we went through the arraignment process. And I told you that there was no drinking then, but then you go out and do some more drinking.
I lost my place to live, sir, and I got confused. I lost my place to live, and I was staying with my friend. I lost my place to live, and I was walking down downtown Gaylord with nowhere to go. And
So alcohol flew into your mouth?
it was a bad decision, sir. It was a bad decision. And if I knew it today, I wouldn't have done it. I won't do it again, sir. Please. I swear, please, sir. Please. Your Honor, I'm sorry. I'm sorry. I'm sorry. I'm sorry, Your Honor. I'm sorry. I'm sorry. I'm sorry. Apologize on you. I apologize on you for letting y'all guys down.
I understand that you're sorry, Mr. Chris. You got a job waiting for you, Mr. Christ?
I get Social Security disability, sir.
Who do you know up here that can vouch for you?
I know Daniel Harrier. He can vouch for me, and April Burney can vouch for me, but she doesn't. She told me she doesn't care about me being in jail.
Why not?
Daniel Harrier can vouch for me. The Daniel Harrier.
What does
My
he do?
friend. He's my church friend. He takes me to church on Sundays. He works at 7-Eleven.
Well, Mr. Christ, you've got quite the criminal history behind you. You know that, right?
Yes, sir. And most of my criminal crimes were when I was young. The gun charge, I had a gun in a motel room and I didn't hurt nobody. They caught me with the pistol. It was my last time going at 2019. I haven't hurt anybody since I was a teenager. You know, I just have a bad drinking problem, my bad decisions when I was drinking, and then person at that time had robbed me. And I made a bad decision and I got a gun. And the police caught me with the gun. And know if I would have turned sober when I had that gun, I would have probably said, what the heck am I doing with this gun? Because I wouldn't have done with the gun, none with the guy, you know? And I happened to have the gun in the motel room and they came for trespassing and found the pistol. That's why I got 9 years. They gave me 9 years prison time for that. I did 5 years, 1 month off that. And I came here to start a new life. And I tried at first. I lived with my friend. She came from Florida. I lived there for 10 months doing good, no drinking, no drugging. And then they moved me out of my own. And I was staying at Timberley Motel. And I started drinking real bad, working a job, doing everything I was supposed to. I started drinking real bad. It's like I was under that shelter, I wasn't drinking. But as soon as I hit the real world and all the problems started hitting me, you know, relationships and then the job things, I got bad with that drinking. I spent 10 months at her house doing nothing but shoveling walkways and at her house and not drinking or anything, going to AA meetings all the time.
Okay, thank you, Mr. Christ. Your criminal history is abominable. You've got an attempted murder charge. You're charged with convicted of driving under the influence causing a serious injury. You've got theft offenses, weapon offenses, multiples, resisting, obstructing, police officer offenses. And now you come up here with very little connection to our community. I let you out on bond once and you get caught drinking while you're on bond on a domestic violence case. So the short answer to your question about can I reduce the bond is no. I think it's best for you if you dry out in the jail, get the alcohol out of your system. You'll be back here. You'll be back here in front of me in less than 2 weeks, and I'll decide what to do at that point. You're likely going to get that much time in jail anyway. So you're just going to get credit for what you're serving right now. So you're not losing anything at that point.
So I
That's all
probably
for
get
today.
so I probably get jail time, Your Honor, also. Or probably
That's a very high likelihood, but we'll decide that when we get to sentencing in July. I'll see you on July 2nd at 9 o'clock, 9:20. Thank you.
Yes, Judge. Thank you.
Good afternoon. Wow, well, look who got out of bed and decided to join us. You know, I tease.
This weather makes you want
Hi, how are you?
Good, you?
Oh, no complaints.
Who'd you like to start with?
Someone with a head. He can't see you.
You can.
There you are.
Okay.
Oh.
I have
Miss
Mr.
Missy,
I had Woodworth out on the bench and I have Keogama.
okay. Miss Missy, do you have
You want
any
'em?
preference on
Nope, doesn't matter to me.
order? All right. Yeah,
Here we
whatever
go.
order you bring them in, it's fine.
Woodwork? No, just wood. Wood.
Hey, sir, at the Grand Traverse County Jail, could I please have your name?
Stephen Woodward.
File call case 268336SM1. Mr. Woodward, you are appearing for arraignment purposes this afternoon, and you're appearing with Miss Mistley, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Ms. Mistley, did you have the opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalties with Mr. Woodward?
We did, and we will waive a formal reading of that misdemeanor complaint, tender pleas of not guilty, and request the assignment of counsel.
So that not guilty plea will be entered. In order to complete a petition for assigned counsel, I need to place you under oath and ask you some questions, Mr. Woodward. Would you please raise your right hand?
Yeah.
Do you swear that the information you're about to give will be the truth to the best of your knowledge?
Yep. Yes.
Thank you. You may lower your hand. What is your phone number
Don't have one.
and your mailing address?
222 Cass Street.
Do you use an email address?
Stephen Woodward 606@gmail.com.
Are
I
you
forget-
working?
No,
go
I'm
ahead,
not.
Ms. Mistley.
I forgot to verify with him earlier, so I was going to ask, is that 606 or 606?
606.
Okay, thank you.
Mr. Woodward, are you working?
No.
Do you have any sources of income or assistance?
I have a bridge card. I make $43 a month on that.
Do you own a vehicle?
Nope.
Do you have any money in a checking account, savings account, or any cash on hand?
Nope.
So in that case, an attorney will be assigned to you. You should be hearing from that attorney within the next week. For you, the next step in the process will be a pre-trial conference. In this case, it will be scheduled on July 16th at 9:30 a.m. and that's in person here at the district court. If you have any changes in your contact information, please let the court know immediately. Not only is that where we will send your notices to, but it's also the information we will give to your attorney in order for them to reach out to you. Do you understand that?
Yeah, because I'm not going anywhere except jail.
Okay, Ms. Messerly, bond has not been set in this case. Is there any information I should know regarding bond?
Well, the praxis indicates that he's charged with R&O, so that may have been the original thought that somebody had, but as the court can see, he's been charged with misdemeanors, not the felonies. So I don't know if that makes a difference in the praxis scoring in terms of the no personal recognizance bond being recommended. But given that they are 3 misdemeanors, Mr. Woodward would request a PR bond to be set in this case. He's from this area. He lives here, that he's not going anywhere. So we'd ask the court to consider that. If the court will not do that, then we would ask for a low 10% bond. Thank you.
Is the hold still in place?
I don't know,
Okay.
because it wasn't clear to me. He had a probation violation hearing on the 12th, this says. He was given.
That was taken care of.
Right. Now,
I was
whether,
jailed twice for that. I
Well,
did 73 days the first time and did 9 days the second time and was released.
so whether or not there's been yet another filed, I don't know.
Judge Hamlin said my release was a mistake, and when I come back, he said 9 days was time served for it, plus the 73 days up prior to that.
I don't really think that Judge Hamlin saying your release was a mistake means what you think it means.
So, Mr. Woodward, the court does have concerns about the allegations that are outlined on the misdemeanor complaints. They are assaultive in nature, and in combination with that, you are also currently on felony probation. And it sounds like there has been some issues with your supervision on that case. So for those reasons, we will do a $10,000 10% bond. Conditions of that bond will be that you cannot consume or possess any alcohol, any illegal drugs.
Can you stop right there, because I'm not getting out. Bye.
So I'm going to continue with the conditions just so that they're on the record and we can reduce them.
We're done. We're done.
To provide them.
No.
She dismisses you.
So I'm going to mute you. We're just going to get through those conditions, okay? You cannot consume or possess any alcohol, any illegal drugs and mood-altering substances, no marijuana, and no non-prescribed medications. You must provide a copy of all of your prescriptions to the district court clerk within 48 hours of your release. You must submit to discretionary PBTs as well as discretionary urine screens, a benchmark urine screen, and 2 times monthly random urine screens thereafter. You may not use or possess any weapon of any kind for any reason. You may not engage in any threatening, intimidating, harassing, or violent behavior towards any person. You must be respectful to all court employees, service, and/or care providers. You shall not have any contact, either directly or indirectly, with Mr. Adam McCreary. You must stay 500 yards or more from him and not go to his place of work or residence. You may not go to any place that Mr. McCreary is or may be. You may not return to 517 Wellington Street while on bond. I'm going to take you off mute, sir. You may have to press something on your screen. Is there a corrections officer there that might be able to assist?
Mr. Woodward, you're muted, so we can't hear you. Do you see
We're
something?
done?
You need to grab a correction. Oh, now I can hear you.
I didn't touch nothing.
Right.
Are we done?
I'm glad that worked. I'm glad it worked. Right. You are all set, Mr. Woodward, and you can let the corrections officer know that you can let the next person in.
I got one headed back.
I'm just looking for, it's a guy over in the jail from Capricorn, I remember his over. It's Sean Crevice, he had an issue with the courtroom. He's in jail for contempt, so I'm just giving the answer.
Have a seat right there, Mr. Holcamp, and tell the magistrate your name, please.
All right. Hello, Magistrate. My name is James Holcamp.
All right, thank you, sir.
Why do I look so weird on this?
So I will call case 268340FY1. Mr. Holcamp, you are appearing for arraignment purposes this afternoon, and you're appearing with Ms. Mistley, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Ms. Mistley, did you have the opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalty with Mr. Holcamp?
I did, and we will waive any further reading, enter a plea of not guilty, and request the assignment of counsel.
In order to complete a petition for assigned counsel, I need to place you under oath and ask you some questions. Can you please raise your right hand? Do you swear that the information you're about to give will be the truth to the best of your knowledge?
Yeah.
Okay, thank you. You may lower your hand. What is your phone number?
My phone number, I lost my phone. That's why I've been stuck in the downtown area for a couple days. I've been trying to get my phone back, but I can give you my my guardian's phone number if that's beneficial.
Yes, it is. What is his number?
231.
And your mailing address? Are you working?
Am I working? I actually have a job lined up. I just have to go to the interview and stuff like that once I have my ID. He told me to get my ID and then come back.
Okay. Do you have any sources of income or assistance?
Yeah, I do.
What are those sources?
I have SSDI income.
Okay. How much do you make per month, and is that income?
How much do I make per month?
Yeah, so how much do you receive from that SSI payment?
About $850 a month.
Do you own a vehicle?
No, I don't.
Do you have any money in a checking account, savings account, or any cash on hand?
I don't have any cash on hand, but I do have money in my account, yeah.
Okay. How much do you estimate was in your account?
I estimate that I have about $3,000 or $4,000, $5,000 maybe.
So in that case, an attorney will be assigned to you. Now, we'll remind you that you have the right to remain silent. Anything you say orally or in writing can be used against you. You have the right to have an attorney represent you and to have the attorney present at any questioning. If you cannot afford an attorney, one can be assigned to represent you. You have the right to have the attorney represent you at all future court appearances. You have the right to a preliminary exam. In this case, it would be scheduled on July 16th. July 16th at 11 a.m. And that is in person here at the district court. You will also have a probable cause conference scheduled for July 8th 2 p.m. at 2 p.m.
July 8th?
You should be hearing from July 8th, 2 p.m.
Okay. All right.
Right. You should be
Sounds
hearing
good,
from your attorney within the next, all right, you should be hearing from your attorney within the next week. So if you have any changes in your contact information, please let the court know immediately, because that's where we're going to send your notices, but it's also the information that we will give to that attorney in order for them to reach out to you. Do you understand that?
Yeah, that makes sense.
Okay, Ms. Mistley, it does not appear that bond has been set in this case. Is there any information I should know regarding bond?
Regarding bond?
Mr. Holtcamp has resided in Traverse City his whole life. He attended TC West as well as TC High. His parents and his grandparents all reside here. He was a CMH client. He is, he's more than willing to continue working with them. His case manager's name is Lauren. He's not sure about the psychiatrist's name, but he's certainly willing to follow through with the treatment plan that is in place. I would suggest to the court that if a PR bond is not feasible in this case for a low 10% bond, I think very likely jail is about the last place he should be. It will do nothing to improve his mental health. And I had asked if he had spoken with Ms. Bush at the jail, but he seemed not to have ever heard of her. So I'm not sure if she has or will be talking to him. Thank you.
So the court does have concerns about the allegations that are outlined in the complaint, and they are assaultive in nature.
Yeah, I heard about what
No,
they said. That's not.
Stop, don't talk.
I'm sorry.
That's
I'm
okay.
sorry. I thought I was being talked to.
Nope, just don't talk about the facts of the case, okay?
Oh, okay. All right. Okay.
You are on the record right now, so you don't want to say anything that could possibly hurt on the future of your case, okay? So listen to Ms. Mistley, okay?
Okay.
So I am concerned about the allegations outlined in the incident offense. I'm also concerned about the previous failed supervisions as recently as January of this year.
January of this year.
For those reasons, I will do a $5,000 cash surety bond. Conditions of that bond will be that you cannot consume or possess any alcohol, any illegal drugs or mood-altering substances, no marijuana, and no non-prescribed medications. You must provide copies of all of your prescriptions to the district court clerk within 48 hours. You must submit 2 discretionary PBTs, discretionary urine screens, a benchmark urine screen, and 1-time monthly random urine screen thereafter. You must not have any contact, either directly or indirectly, with Nick Batista or any members of his family. You must stay 500 yards or more from him and not go to their place of work or residence. You may not enter the open space in Tantrum City for any reason. You may not use or possess any weapon of any kind for any reason. You cannot engage in any threat, intimidating, harassing, or violent behavior towards any person, and you must be respectful of all court employees, service, and/or care providers. You must be compliant with a mental health treatment plan. That would include attending all appointments as scheduled, taking your medication only as prescribed. You need to provide verification of that compliance to community corrections. Okay?
Yeah. Okay.
Right.
I
If you are
understand.
eligible for the if you are eligible for the jail diversion program, you will also need to enroll in that programming. Okay?
All right. What does jail diversion mean?
It's a further assistance. I believe if you are able to speak with Ms. Bush, she might be able to better outline that for you, and then additional services that could be helpful for you. Okay?
What if they made that up and like I didn't really.
So
you don't want to talk about.
We're not going to
have any additional.
Wait, sorry. Can someone just talk to me and tell me what's going on? I don't really know what's going on.
Yeah, stop talking about the facts of the case.
Oh, okay.
You're going to talk to our assigned attorney about that. What the magistrate just asked is whether or not you understand the bond conditions she just said.
Oh, okay.
Okay? Do you understand?
Mm-hmm.
Is that a yes?
Yeah, I do understand.
Okay, thank you.
I understand I can't go to the open space or.
Yes. Right. So you will receive a copy of those conditions, and you are all set and free to let the next person in, okay?
All right.
Thank you.
I get the leave for that?
I didn't hear what your conditions were. I'll find out for you. I got one headed back to 105. You're up, Mary. Have a seat right there, Mr. Finstad.
There.
Yeah. State your name for the magistrate.
That's Jacob Finstad. Looking at here.
5080-SM1. Mr. Fenstead, you are appearing for arraignment purposes this morning or this afternoon, and you're appearing with Ms. Mistley, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Ms. Mistley, did you have the opportunity to review the allegations and the probation violation report as well as the recommendations with Mr. Fenstead?
I did, and he has elected to admit the violation.
Mr. Fenstead, do you understand that by admitting to those allegations that you would be waiving your right to a hearing and all of the rights associated with that hearing, including being able to speak with an attorney? Do you understand all of that?
Yeah. Yes, ma'am.
So in that case, we will schedule you for a probation violation plea and sentencing in the near future. I will ask that it be expedited because you are incarcerated. However, it will be scheduled by the judge's clerk, so I'm not exactly sure when that date and time will be, but it will be soon.
I just got released from here on Thursday. I just dealt with all this.
You wish to be heard on bond?
No.
So Mr. Fenstead, you will, the underlying case is stalking, and this includes allegations involving non-compliance with the GPS unit. So for those reasons, I will remand you in jail pending your ability to see the judge.
Okay.
If you don't have any additional questions, Mr. Fenstead, you are all set and free to let the next person in.
I don't think I've ever heard Miss Mistley, when asked if she had something to say regarding a client's bond, I don't think I've ever heard her just flat out go, no. She had zero defense for that guy facing his stalking charges.
And your name, sir?
Donald Hendricks.
Mr. Hendricks, I'm Harris Blanchett. I am the Justice of the Peace here in San Jacinto County. And my job today is to let you know why you're in jail, read your rights, make sure you understand them, and then set a bond so you can get out.
Could I please get a low bond, sir? They towed the car in, and if I can get a low bond, I can get out of here. Please.
We'll discuss that in a minute, okay?
Yes, sir.
You're charged with the offensive possession of a controlled substance, penalty group 1, greater than or equal to 1 gram, but less than 200 grams. That's a felony in the 2nd degree. You have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys that represent the state. You have the right to remain silent. You're not required to make a statement. Any statement you make can be used in court against you. And you have the right to stop any interview or questioning at any time. And because this is a felony, you have the right to an examining trial. Do you understand those rights?
Yes, sir.
Or do you need a court-appointed attorney, or you're going to get your own?
Excuse me, sir?
You need a court-appointed attorney,
Yes,
or
sir.
you're going to get your own? No? All right. Are you a citizen of the United States?
Yes, sir.
Are you currently out on bond for any other charges in Texas?
Yes, sir.
Where at?
Right here.
What for?
Excuse me?
What are you
theft.
on
It's
bond
theft.
for? Do what, sir?
I think it's theft.
Theft is it a misdemeanor or a felony?
It's a felony.
I see. I'm going to set your bond at $10,000 and then notify the court that your case may be in. They may want to adjust that bond, but at this point in time, because of your criminal history and being currently on bond for a felony already in this county, the judge may want to go back and pull your first bond. All right. Do you have anything I can put on to you or answer for you or help you out with?
There ain't no way you can lower that bond, sir?
No, sir. I probably shouldn't even be setting it since you're already on bond in this county.
Yeah, but my bond's paid off.
Well, it
I
doesn't
haven't,
matter.
I
It's the
don't run,
fact
I'm
that,
not fixing to run or nothing.
this the fact that you're currently on bond in this county. The statutes say I shouldn't even be setting your bond.
Well, thank you, sir.
All right, take care. Take care.
10,000, you said?
10,000, yes, sir. At this time, I'm going to review the fact that I have the authority to set it. I may have to revoke that and let that go back to the judge that is currently got your case. I'm going to check and make sure your other case has been filed. All right, thank you.
Is that it?
No, we have one more to go. A Mr. Timothy Deckard. He has a protective order I need to put on him.
Oh, okay. You didn't give me that.
I'm sorry.
Okay, let me go get him.
All right, thank you.
You're welcome.
Thank you, sir.
Uh-huh. Are you Timothy Deckard Jr.?
Yes, sir.
Mr. Deckard, I'm Harris Blanchett. I am the Justice of the Peace.
How you
I
doing?
received today an application to have a protective order put against you for the crime in which you are in jail for assault, family violence, a felony in the 3rd degree. Well, let me explain this order to you, then I'll send it over there for you to sign and get a copy of it. Okay? So today you are being ordered to, I am putting an order against you to protect, is it Courtney Adams? That's your spouse?
Yes, and I want to know, Judge, where did this come from? How do I get this case? Because did nothing go on between me and Courtney. She I really don't know what's going on right now.
Well, I don't know. I'm not the judge that saw your original case. That judge determined there was enough probable cause that you had committed the offense that she decided to detain you and give you a bond.
What?
And that judge took care of that. All I'm doing is putting this order against you. I don't know anything about the offense itself, but
Yes,
I'm
sir.
telling you that you cannot commit family violence against a protected person. All right. You cannot commit an act in furtherance of an offense such as trafficking or stalking that person. You cannot communicate directly with that person protected by this order or a member of the family or household of a protected person of this order in a threatening or harassing manner. You cannot communicate a threat or to any person or person protected by this order or a member of the family or household of this protected person. You cannot possess a firearm or ammunition. You cannot go within 200 yards of the residence of the protected person, which is Oak Street in Cold Springs. Let me go down to if you commit any violence or violate this order in any way against a protected person, you will be rearrested.
Although with this judge, I would kind of expect it to come off something like, I say, foghorn leghorn style.
And this order is in place until September the 27th of 2006. Do you understand that?
Yes, sir.
Okay, I'll be sending a copy of this order over there for you to have and get a copy of. And who's the officer there with you?
I don't.
Baxter?
Baxter?
Yes, sir.
Will you be taking care of the paperwork?
Yes, sir.
Okay, I have a place for you to sign showing that you are officially serving him with a copy of the protective order.
Yes, sir.
All right. Do you have any questions, Mr. Deckard? I mean, I know you're talking about the validity of the charge, but I have nothing to do
Yes,
with
no,
that.
I understand, as far as question, I understand, everything that you have said to me, Judge.
Okay.
Well, I'm just,
Well,
going
you
on with
just
it, I
need
mean,
to, I don't know if you intend to make your bond or what, but wait till you go to court and then present the evidence you have toward your innocence.
okay, and, this order is for how long?
For 90 days till
90 days?
September the 27th.
Dang, man. Okay, all right.
If you have anything at that residence you need to let someone else go get it for you. You cannot go to that residence or within 200 yards of that residence for the next 90 days.
Okay, well, I think I'm 200 yards from it now, okay.
We
Now,
may have to put you in the back room.
yeah, you know where that resident is, don't you?
Yes, I do.
Yes, sir, it's right across the street right here, right? Okay, yes, sir, I understand what you're saying, though.
All right, sir. Thank you.
Alrighty, is that it?
That's it, ma'am. Yes, ma'am. Thank you.
You're
Hey,
welcome.
excuse me, Judge,
Uh-huh.
you gone?
No, I'm here.
You have, and what do you say, do I have another bond or something?
No, sir. There's no other bond on this. This is just an order to protect the victim.
Okay.
Okay, good morning. I'm Judge Hamilton with the.
Okay, before we go to Judge Hamilton, I gotta share with you guys. If you hadn't seen it on, there was a video that I did that I put it on, but there's two of them, all right? I made him into a colonel. Colonel Blanchett. It even says so on his name tag. And then there is... He had to have the hat. I love it. I love it so much. I think he looks very good as a colonel. Oh, it's a general. It's what ChatGPT gave me. I asked for a colonel. Oops. Oopsies. I don't know the difference, but it looks good. All right, back to Hamilton.
Amarillo Municipal Court. Sir, on the front row, if you cannot sit up, we'll just have you go back to your pod. Thank you. Mr. Smith, did you decide you just wanted to get these done?
Oh, 2 years ago, I got that ticket from when I was working down here. So I went to court for it, and they made me do weekends, and then I forgot I had the tickets.
Who made you do weekends? That must have been a different, we don't do that. So it must have been a different court.
Yes, by WT, the college WT by Canyon,
Uh-huh.
and I went to court there. They made me do sign for 12 days for the weekends, and then I came in, got processed, and then they said I had warrants. $2,000.
So are you going to be in jail?
I'm gonna be in jail till Sunday morning.
Mm.
That's it. I get out, but I can do weekends for y'all too.
You don't do weekends.
Okay. Y'all can set up a payment arrangement. That'd be great. I'd pay it.
Hey, Judge. He got sentenced on a county court of law 1 case, and he got a weekend commitment for that.
Thank you so much. So back in 2025, you saw Judge Cates while you were in jail, about August of 2025. Here's the deal. You got this ticket in June of 2025, speeding 48 and a 35. You were supposed to come to court within 12 days of the date of that citation. You did not do that. A warrant was issued for your arrest. You were arrested in Randall County at some point in August of 2025, and you were held on a bond surrender out of a Smith County case. So Judge Cates gave you your jail credit, released you so that you could go to Smith County. When you got out of Smith County, you were supposed to come back and see our judge just as soon as you got released from Smith County. Whatever happened on that Smith County case?
Well, I'm on probation for it, but
how long were you in jail in Smith County?
like a week or two. I don't remember.
It's important.
I think it's like a week or two. I don't remember. Mom had just passed away, so I was trying to give everybody situation, and I wasn't taking care of my responsibility as a man. Trying to get people moved from her house, get them in their own spot, and I wasn't taking care of what I had to take care of.
Where do you work?
I still work at Diamond. I'm a foreman now.
Diamond?
Diamond is a asphalt company.
Oh, I see. Okay.
Yes, ma'am.
How much do you make an hour, sir?
I made 27, so I will be able to do. I'll be able to pay y'all.
No, I just have to hold on. Let me write something down here.
Yes, ma'am.
Okay. Here's what we need to do, Mr. Smith. On the capias that you owe $221, I'm going to give you the $150 jail credit that you're entitled to. That's from today. You don't get credit for yesterday. I'm remanding you on the $71. You can just pay that. Or if they'll hold you till 8 o'clock tomorrow, you'll get credit. Okay? But you're going to be there till Monday at 6, right?
Sunday at 6 in the morning. So that's
Sunday or Monday?
Sunday, right? Sunday.
No, Judge, he's got three KPS JP1 tickets we were going to talk about when you were done. He's got to sit. If he doesn't pay it, he'll be here till at least July 8th.
Oh, goodness. Okay. Thank you. So,
I'm not.
okay, wait, talk to me, Mr. Smith. Talk to me. I'm going to remand you on the $71. That just means I need them to hold you till tomorrow at 8 a.m. So, or you pay the 71. Now, but I need you to be super responsible about what I'm fixing to tell you. Now, and Millie, you're going to have to help me on this. So, Mr. Smith, you have two options on the August 15th, 2025 tickets. You can either plead guilty on those. I'm going to get somebody on Monday. We can't do it today. I'm going to get somebody on Monday to check your jail credit in Smith County. You should be time served on those because the offense happened, this August 15th offense happened prior to you spending a week in Smith County, if you are correct about your jail credit. So you can either plead on them now, let me check your jail credit Monday morning when their records department is open, or you can plead not guilty and I can set a bond. And then we'll check, Millie or somebody else will check with Smith County on Monday. If you plead not guilty, I have to see you. If you plead guilty and you are time served, like you're like, I know that I spent that week there after I left Randall County in August of 2025. If you're like, I know with 100% certainty that I spent a week in Smith County, then you wouldn't have to come back and see me. You would just have these convictions for no seatbelt driver, no driver's license, and no insurance. Does that make sense to you? Do you understand what I'm saying?
Yes, ma'am.
If you're time served and you've pled guilty, I don't need to see you. If you're not time served and if you're time served and you don't plead guilty, if you plead not guilty, I have to see you when you get out. You have to change your plea Or you can plead not guilty. If you think you're not guilty, plead not guilty and we'll set a bond and we're done. But it's no seatbelt driver, no insurance, no driver's license, and it's all from August 15th on South Georgia, about 34th in Georgia, right around there.
I went to jail for that.
Yes, that's the day you went to jail. And because Judge Cates saw you the next day and she talked to you, I guess that case hadn't been filed yet, so she didn't have the new tickets, but she had the old one. So she talked to you on the June one, which we just resolved. So the June one's resolved. You just have to pay the $71 or sit there till tomorrow at 8. The August one, the one that happened that when they pulled you over then, I'm sure they found the bond surrender out of Deaf Smith County, took you to jail. I'm sure that's what happened. On August 15th of 2025.
Now, I have to call. Well, I need to get a hold of Amarillo bail bonds. That's what I use.
Okay, that has nothing to do with me. So my point on these 3 tickets, on the no seatbelt driver, the no driver's license, and the no insurance from August 15th of 2025 is you can plead guilty and I'll check your jail credit on Monday. And if you are correct, you don't need to be here. But if you were incorrect about your jail credit, you'll need to be here.
For how long? Because I don't know.
Here, I'm not there. Here at my court.
Oh, yes. Let's do guilty.
I'm going to let you out either way on that.
Let's just do guilty so I can get everything taken care of. So I can try.
Are you 100% sure you were in Deaf Smith County for a week last August?
I don't know, but I just want to get it taken care of.
Okay, so if you're wrong about your jail credit, then you need to show up.
Yes, ma'am. And I will.
Okay, so the moral of the story is you should just show up.
Yes, ma'am.
Now, if the JP leaves you there in jail, which I think you'll be able to pay, hopefully, whatever they tell you to. But if the JP leaves you in jail, then we'll still take care of it on Monday. So Millie, that's what I mean. I need the jail credit checked Monday morning with Deaf Smith. And number 2, if he's still incarcerated, I want to follow up with him Monday morning. Okay?
Yes, ma'am.
Okay. Okay, so you're pleading guilty on all 3 of these? The no seatbelt driver, the no driver's license, and no insurance. Okay. I'm going to find you guilty. I'm going to give you the 1-day jail credit on each one of them. And then I'm going to order the clerk to check Deaf Smith County jail credit. But for you have to be here when you get released by 2 p.m. unless I talk to you again in the jail on Monday.
I'll be here.
I don't know. I guess it depends on whatever happens between you and JP4. The moral to the story, Mr. Smith, is you got to take care of your stuff.
Yes, ma'am.
Because it looks like that's the whole reason you're in jail today is because you didn't take care of prior arrangements.
That's my bad. I apologize.
It is your bad. You're too old. You've got too big of you're an important guy. You've got a good job. You need to not be wasting your time not just taking care of the things you need to take care of. Okay? Okay. We'll figure it out by Monday. And if you don't hear from us, you make sure you show up when you get out of jail. Okay?
I'll be here.
Okay. Thank you, Mr. Smith. Have a good day. Mr. Cotter? Good morning, sir.
Morning, ma'am.
Well, we have a bench trial set for you on July 16th on the previous public intoxication.
Right.
But looks like you were charged over at Hodgetown last night with public intoxication. Sir, what do you want to do on that one from last night? You can plead not guilty, no contest, or guilty.
If I go non-guilty, do I still get a PR?
Oh, yeah. I'll give you a PR bond.
You
You can go guilty or not guilty. I don't care.
Not guilty.
Okay.
So,
That was really late, 2,300 hours. Why was the game not over?
no, ma'am.
Okay. Well, who won?
I don't know.
Were you at the game?
I was. I'm pretty sure the Salt Pills did lose.
Okay.
Last I remember it was 5-0.
Okay.
Pills were at 0.
That's unfortunate. Okay. I'm going to give you that PR bond. Make sure you show up here on the date and time listed on the bond. Should be Monday at 2. Okay.
Yes.
Don't forget you can come at 11 if you want to avoid the 2 o'clock crowd.
Yes, ma'am.
Thanks. We'll see you then.
Thank you.
Okay. Mr. Zamora, come on up. Are you still working at A-Team Rentals?
No, ma'am, I work at Rock Solid Builders.
What do you do for them?
Painting, remodeling.
How much are you making an hour?
Only 15 over there.
How come you weren't keeping up? How come you didn't even make a payment on this new payment plan?
Honestly, I lost my job at A-Team, and then I kind of been struggling since, and seemed like I don't know, I had to pay my car, and then the tire blew, and I just been short on money, and that's it. But I got a job. I do have a different job now, so.
Okay. Do you support any dependents, Mr. Zamora?
I mean, just my daughter, but I'm not fully.
She live with you, or does she live with the mom and you just pay her or help her out some?
Yes, ma'am. Second part.
Okay. Are you court ordered to pay child support?
No, ma'am.
Okay. How old is your daughter?
She's 8.
Okay. Wow. What would she think of her dad being in jail?
Well, I just got out of prison in October, so yeah.
You did? What'd you go to prison for?
Evading arrest in a motor vehicle.
Okay. I'm gonna just ask, why were you evading?
I don't know. It was right. It really was right after my mom had died, and I was not in the right mental state of mind, and so I wasn't trying to go back to prison. You know,
I know, but
y'all used that joke earlier about how when family members pass away, that means it's time to go commit crimes. And now we have a second one using that as their excuse. Yep, right there it is. Yeah. How many relatives does that apply to? Because I think we all need to be concerned if that's the standard.
So you'd been in prison prior to that?
yes, ma'am. This was my second time.
Uh-oh. Okay. What'd you go to prison for the first time?
Burglary rehabilitation. Well, really, I wasn't in burglary. I was just caught in a house. This is when I was on drugs, and I was caught in a house, an abandoned house, and they charged me with burglary rehabilitation. So.
Here's my problem. I'm sitting here looking at all the tickets you've gotten, and you've gotten a lot of tickets in the past. And now I see why there was a space of time where you didn't get any. But you should know, Mr. Zamora, that when you make a payment plan with us, we need you to keep up with it or come and talk to us.
Yes,
right?
ma'am. Yes, ma'am. I was actually gonna go up there last week. Somebody told me that if I should go up there and talk to y'all, that y'all wouldn't issue no warrants, and I was like, I don't know. I don't know. I was being dumb.
Yeah. You owe $2,079. I'm going to give you 2 days jail credit. What was the last day you worked?
I just worked yesterday. Friday or Thursday, Friday. I've been work all week.
Well, the police picked you up at about 2:30.
Oh yes, ma'am. Well, I was that morning. All we did was I just went out to the shop, and then we went to the job site, and because the dude that I work for, he owns all the TNT stands around town, like the fireworks stands, and so they've been more focused on that than the remodeling thing. So we caught it early, and I was supposed to go pick up my check, but I got arrested. So
Okay, so you've got a check waiting on you?
yes, ma'am.
Okay. Mr. Zamora, let's try it one more time, okay? You got to be here by Monday at 2 p.m. So you need to go get out, call your boss, text them, whatever, and say, I've got to go to court Monday. I've got to go see the judge. I've got to reset my payment plan. Can I come pick my check up first so I can make a small payment? Okay,
Sure.
let's try that one more time.
Okay.
We need a fresh start. You need a fresh start again. It's okay.
Thank you.
We'll do it one more time. We'll see you Monday. Thank you.
Thank you.
Yeah. Ms. Norris, if you join us fully. Mr. Watts, do you have a matter ready to present?
Judge, I'll need to meet with Mr. Holt and Mr. Leal.
All right, very well. Can we set up a breakout session between Mr. Watts and his clients that are apparently at the jail?
Holt is at court security. Mr. Leal, I believe, is at the jail.
Let's deal with the jail case first. And I think I'll move on with Mr. Patterson then. Mr. Patterson, you have one case on this docket?
Yes, Your Honor. Devin Ward, he is at the courthouse.
Very well. Court call State of Kansas versus Devin Michael Ward, case number 2024 CR 452. Darren Patterson appears as defense counsel, Amber Norris on behalf of the state. Devin Ward?
Yes, Your Honor.
He appears at the Butler County Judicial Center Zoom location. Matter comes before the court at this time for hearing in relation to a warrant to show cause alleging probation violation, failing to pay, failing to report as directed, as set forth by Ms. Moore in her paperwork. What are your client's intention here today, Mr. Patterson?
Judge, I have discussed this with my client. I can tell the court that my client is going to waive hearing and he will be stipulating to the specific violation that he failed to provide documentation of a hospital stay as the reason that he missed reporting on April 3rd, 2026.
All right. I'm curious, the court had received a number of proposed exhibits from you, Mr. Patterson, which apparently addressed this issue or intended to address this issue. Were those previously shared with Ms. Moore?
Judge, this is the first that they've been circulated. I received them yesterday and circulated them.
You also had a failure to pay as directed. What are your client's intentions regarding that, Mr. Patterson?
We would be contesting that if we need to. I probably need to ask for continuance on that issue. He has some severe medical issues where he is off work, not able to work at this point, so that he has not been working for months now. And it's because of a medical issue, but he had been paying before then. And I'm not sure what the balance is. My client doesn't know what the balance is. And on the warrant to show cause, it didn't know what the balance was. So I'm not really sure what the balance is, but he has been paying.
All right, we'll address that further. Mr. Ward, it's the court's understanding that you're not contesting that you essentially enter a no contest statement to the accusation that you failed to report as directed. Is that correct?
Yes, Your Honor.
And of course, you understand that you do have a right to a due process hearing where the state has the obligation of proving that allegation by a preponderance of the evidence. In fact, all of their allegations. You can contest the state's evidence with your own, confront the state's witnesses unless good cause was shown, have the assistance of your lawyer. And I do need to point out to you that the court could incarcerate you for short or even longer periods as a result of this violation. Do you understand that?
Yes, Your Honor.
And so do you waive a hearing in the case and stipulate and agree at least that you failed to report?
Yes, Your Honor.
All right. Court finds that the defendant has knowingly waived his right to a hearing and agrees that he failed to report as alleged in the warrant to show cause. There's obviously some explanation that's intended here. The court understands it's a relatively straightforward violation. What are you offering in mitigation, Mr. Patterson?
Judge, I would tell the court that I provided Exhibit A. Now, I would tell the court I asked my client to provide discharge documents, and he's lost those, doesn't no longer have those, but I asked for some documentation that would support his statement that he was in the hospital on that day. So Exhibit A is from Wesley Medical Center. It's a document concerning the payment for certain services, but the date of service very clearly was April 3rd, 2026 at Wesley Medical Center. So that there was a medical issue. But the other documents are submitted to show a continued medical issue that has elevated to him being required to go to the Andover Heart Hospital, where he is going through some things dealing with a heart issue. So it shows a current history of medical issues, but also on the one day, April 3rd, does show that services were provided by Wesley Medical Center to him, and his statements are going to be, I was in the hospital. So he never provided that, Judge. That's on him. We've entered into an agreed recommendation for a 48-hour sanction because he did provide the paperwork. And that he understands that's on him. He's got to do that in a timely manner. So that's what the documents are intended to show, Judge.
All right. Ms. Norris, your office's position?
Your Honor, I haven't had the opportunity to review the documents, and I would agree with counsel that there is a date of service date of 4/3, which does coincide with his non-appearance at probation. I do believe that we'd be recommending the 2 days in the county jail as a sanction, and that the court do an extension of defendant's probation for at least 6 months, if not 12, so he can complete and pay and finish this case.
All right. Ms. Moore, do you have anything to add to Ms. Norris's statement?
No, Your Honor.
All right. Mr. Patterson, any further recommendations for the court?
Judge, I can tell the court my client is going to ask the court to delay the 48-hour sanction because of his medical issue. I let him know that that is clearly up to the court and something generally this court is not inclined to do. But I do want to make the court aware that he is making that request. Nothing further.
Is there something immediately compelling about his medical condition that would make some later time more acceptable than today?
Judge, I went to see him personally at the courthouse before this hearing, so I could kind of get an idea of what's going on with him. And he appeared to be in great physical distress because of the medical issues. If they're severe enough, I assume they're going to do a medical check on him to decide if he's even eligible to be in the jail. But I think he can elaborate on that more than I can.
Do you have any statements you wish to make to the court, Mr. Ward, in mitigation?
Yes, Your Honor. I was going to see if I could delay it for about a week so I could help a little bit more. Like when they did CPR on me, they broke my chest and my ribs, and I can't even lay down. Like I try to sleep sitting up. So I was going to see if I could delay it for a week so I could at least heal up a little bit more. Maybe I could lay down by then. I'd be able to get some, I sleep sitting up right now. I can't hardly breathe.
Is there a reasonable expectation, Mr. Ward, that 1 week from today you'll be that much better?
Well, they said it was going to be anywhere from 4 to 6 weeks before I'd be healed up, and that puts me at 3 weeks since I've been discharged next week. Today's 2 weeks from I got discharged from the hospital from Kansas Medical Center 2 weeks from today. So another week I might feel better. I don't know, maybe 2 weeks. But I mean, I still got burn marks on me from when they shot me 16 times with the defibrillator.
Sounds like to the court you're lucky to be alive right now, Mr. Ward.
Yes, that's exactly what they told me.
Very well. The court has found a substantial material violation of the terms and conditions of the defendant's probation, failing to account for failing to report to his officer as directed. Mr. Ward, you could have avoided a lot of problems here if you would have just communicated with Ms. Moore in a very, very prompt manner, either by telephone, text, email, whatever it takes, but just get her the message as to what's going on with you. A 48-hour sanction is appropriate in the view of the court, and then the court will reinstate your probation and extend your current probation period for 6 months past the existing expiration date. So the current date plus 6 months is the new expiration date in the Devin Ward case. regarding the request to defer. I don't like doing that, Mr. Ward, but I have looked at your documentation provided by your attorney, and what you and he is telling the court has been backed by some medical paperwork, which is a rare circumstance for this court. I've taken that into account, and I'm going to defer your reporting for a period of 1 week. You need to report to the jail at 2:30 p.m. on next Friday, and that date would be July 3. Now, that's a holiday, but not for them.
Yeah.
So 2:30 on Friday, July 3rd, you'll need to report to the county jail. I want you to heal up for a week. And then you just need to take it easy in the jail for 48 hours. I mean, there's not a whole lot of activity you need to do there anyway. And you just need to contemplate while you're in there that you need to make sure you communicate totally with your court services officer in the future to avoid these problems.
Thank you, Your Honor.
Because of the recent medical issues Mr. Ward has had, the court is not going to consider his default on payments to be something to take action upon. But Mr. Ward, you need to make regular and consistent payments. Do you understand that?
Yes.
And if you're
I
having
will
any
soon get
type
back to work.
Okay. And if you're having financial difficulty, you need to either tell or, even better yet, document for Ms. Moore why you're having financial problems so that she can work with you on payment. Okay?
All right.
All right. So do you know when you need to report to the jail?
Yeah, July 3rd at 2:30.
That is correct, Mr. Ward. And his probation is reinstated with that condition.
And Your Honor,
Okay.
his expiration date would have been April 8 of 2025.
2025 or 26?
Looks like 25.
I thought there was an extension.
Ms. Moore, if you can assist the officers of the court with this.
Okay, and Judge Journal entry states sentencing was April 8, 2025, so it should be 2026.
Oh, Your Honor, it's actually November of 2025, when he had his last probation violation. And at that time, Your Honor, it doesn't look like it was extended. It was revoked and reinstated. And he served some jail time.
That's
Is
correct,
there
Your
an
Honor.
extension in the file, Ms. Moore?
No, Your Honor. He was sentenced back in April of 25. In November, the court stated that he could have his case paid off before his term date, and there was no need for extension at that time.
So no, I think we need a 6-month extension, but from today's date.
The court would agree.
And I apologize, Judge. I need to see if I can have a brief breakout with my client. I'm seeing something that is kind of maybe a legal issue I need to discuss with him.
Just a moment, counsel.
And I can tell the court and counsel what I'm looking at.
Well, wasn't the warrant issued here within 30 days of the date of the original expiration, Mr. Patterson?
It is, Judge.
It was.
It was, just barely. So
This is getting juicy.
Barely counts.
yeah, it does. Never mind. No breakout room needed.
Very well. With that clarification, the court will extend probation in this case 6 months from today. Today is June 26th, so it's extended to December 26th of the year 2026. You can get the case paid off sooner than that, Mr. Ward. You might be eligible for early release.
Okay, thank you.
And I hope you can achieve that while preserving your health, Mr. Ward. Okay, don't forget to report to the jail next week, Mr. Ward.
I hope.
Okay. Anything further, Mr. Patterson
Sorry, Your Honor. Thank you.
or Ms. Norris?
No, Your Honor, thank you.
The Devon Ward matter is in recess at this time. This juncture, you can leave the courthouse area, Mr. Ward.
Thank you.
All right, we have to take just a tiny little break because I need to show something to Eileen Carlin. We made a regear quarter a couple months ago, and she doesn't remember what it looks like. So I am pulling it up right now. I know I have it. But I make a lot of AI characters for the stream here. Okay, I'm too far. Did I put it in? I didn't. I posted it to Discord. I know I did. I guess I'm gonna have to go back. Oh, there it is. I found it. Yeah. So we did it as if it were a proof set. This is the Jared Regier quarter that we made. Stop it. It's all very important work. What? Charlie, this is Eileen and Carlin. You silly butt. So yeah. So we have the date that he was licensed, and we have the official Kansas seal on the back of it. If this were a real coin, here, I'll turn this off so you can see, because his licensing date was September 27th, Linda Adams' birthday, of 2019. And yep, Assistant County Attorney, Butler County, Kansas. And so if this were a real coin, this is one that would come in one of those, like, coin album books, and then you'd flip it up and it'd be, the two, yeah, it would be a very special coin. Well, how could I forget? It's the same day as Jared Regier. No, I'm just it'd be one in cellophane. 0 cents. Yeah, that's the official Kansas seal. Yeah, I made sure to make sure that was on there. Yeah, I wish that it was something that we could legitimately, honestly, like, make into a coin. That would cost thousands of dollars, though, because they'd have to make a metal imprint stamp for it. So we just get the digital version. But anyways, yeah, I had to share that with her and with all of you. No, a cull is an error. A cull is a glob of metal that is formed out of place. Cull is basal state. I don't know what that means. It would be a collectible. It would be absolutely a collectible. Well, I did put this image because it was the same night that we did the Middleton image. Y'all remember that one, I'm sure. Hold on. Oh, okay, computer. My goodness. All right, so you were here, Eileen, because you put input in. You put input in, sweetie. And you helped on this too. You must have been very tired. Yeah, it was that night. Yeah. You must have been very, very sleepy. I know. He honestly, he is a true to heart character all around. I think ChatGPT would give me an error that it violates community standards, because I've gotten that error many times on the very most innocent of things. Yep, we have a smile version too, but I'm getting full on my studio here. One of these three. There's two smile versions. I think this one. Yep, that's there we go. I have a feeling he loves chatting with people in the mornings. I have a feeling he'll do something like his morning coffee clutch or something, where he just, talks about the weather and the goings on in the county and things like that. The man knows everybody's business and everybody's business, You had to get him in a bonnet. No, because it would think I was trying to make kitty prawn. The hairless, scrawny man. I mean. Oh. Yeah. Well, that's what Jen Callum was just saying. Exactly, Penny. All right, I'm gonna put the case back on.
Have a good weekend, Judge. Thank you.
Mr. Patterson?
Judge, who do we have on from the Sedgwick County Jail? I assume they only have one of our people.
Yes, I have Mr. Salter here.
Okay, I thought the O'Hara firm was representing Mr. Salter. Are they on the meeting?
I don't show them on the meeting.
I'm sorry?
They are not on the meeting.
And Your Honor, he said at that time he was going to hire his own attorney on his first appearance on May 15. But I've not had any discussion or communication with anyone regarding Mr. Salter's case.
Okay, my assistant had put on the sheet that the O'Hara firm was representing Mr. Salter. Were they retained counsel at earlier proceedings, Mandy?
Yes, they were retained counsel previously, so I don't expect them, unless he's retained them again specifically for the warrant to show cause, I don't expect the O'Haras or anyone from that office to appear
Okay. Can Sedgwick County officials get Mr. Salter in front of the Zoom camera at this time?
Yes. All right, just don't touch the computer. If something goes wrong, stand up by the door. I'll
Yes, sir.
start in here.
Okay.
Push the button.
All right. Yes, sir.
David Salter,
Yes, sir.
you're here on State versus David Salter, Butler County case number 2024 CR 509. Amber Norris is appearing for the state, but you don't have a defense attorney appearing. Mr. Salter, can you explain?
I was going to get one. I just couldn't afford it. Me and my girlfriend were having a kid, and there was just some things happened, and financially, I couldn't afford one, sir. Unfortunately. So, yeah, I apologize about that. So, yeah, there's a lot of financial obligations came into play, and yeah, yes, sir. So,
And you're asking for an attorney's assistance on an appointed basis then?
yeah, I mean, really, I'm getting ready to, I mean, I'm getting ready to do KDOC, right now for Cedric County, and I'm going to do some time there. I don't know if we can, I don't know what we can do anything today. I just it's been a lot going
Your
on.
case
Sir.
just got a lot more complicated based on what you just
Yes.
announced.
Yes, sir. Yes, sir.
You're
Yeah.
going off to Department of Corrections custody and would hardly be in a position to be able to successfully complete probation in the community here in Butler County.
Yeah. That's right. Yes, sir. Yeah. And I'm also getting ready to have a kid as well. Just talked to my wife 2 days ago, so it's been a little bit of a long, life-changing time since I've been here.
Okay, Mr. Salter, let me ask you a question.
Yes, sir. Yes, sir.
Are you going to go do prison time on Cedric County case 2023 CR 1504?
Yes, sir. Uh-huh. Yeah.
Okay, well, the problem is this case runs consecutively to that. That's a serious implication for you. If
Okay.
by to resolve your case today, you end up with a box card prison sentence. I think
Okay.
you agree with that, wouldn't you?
Yeah.
Well, you should agree with it because this is a serious matter. I
Okay.
don't want to impose that kind of actual sentence in prison without you being represented, Mr. Salter.
Thank you. Thank you. Yeah.
You don't have the financial resources to hire a lawyer. I'm going to appoint one to represent you.
Okay.
I'm going to reset you to next month's docket, and we're going to get an attorney on board for you. How long are you going to be in the Sedgwick County Jail?
I'm not too sure, man.
Have you
probably a
already
couple.
been remanded to prison custody?
Yeah. Well, no, the 28th of May was when I was my sentencing. The 28th of May, sir. Yeah. So.
All right. Mandy, the date of next month's docket.
It will be July 17th.
We'll reset this case to 2:30 p.m. on July 17. Counsel will be appointed for Mr. Salter. We just had the impression you were going to show up today with retained counsel.
Yeah, I know. I apologize, sir. I apologize. So
I just don't want you compromised by that.
Okay,
So
yes, sir.
appoint a lawyer, and we're going to take this up in July. Now,
yes, sir.
I suppose Casper will tell us where you're housed if you are sent out to DOC custody.
Yeah, I mean, it's a pretty long wait here, so I should be here. You said the 17th of July. Yeah. Yeah, it's a pretty long wait, I think. So.
All right. I want to thank Sedgwick County's officials for their patience and being able to get our inmate on the meeting here this afternoon. I think for now, that concludes the David Salter business. We'll take this up July 17 at 2:30, and you're going to need to be on the meeting at that time too, Mr.
Yes,
Salter.
sir. Absolutely.
Okay.
Absolutely. Yes,
All
sir.
right.
All right.
All right. If there's nothing further, then the David Salter matter will be in recess at this time. And again, we'll take him up next month.
Thank you so much.
Okay, I've got an
Appreciate it, sir. Thank you, man. Yep.
Okay, let's get Sedgwick County muted. Okay, there we go. Who do I have at Butler County Detention 2?
This is Christian Leo, Your Honor.
Okay. Thank you. Are you ready to go on Christian Leal, Mr. Watts?
Yes, sir.
Let's take up his case. This is State of Kansas versus Christian Michael Leal, case number 2024 CR 322. James Watts appears as defense counsel, Amber Norris for the state. And Amber, at some point, I will need you to go ahead and rejoin fully with audio and video. I know you're still there. Christian Leal appears at the jail Zoom location. This matter comes before the court at this time for review of the defendant's probation. I think the current allegation before the court is that the ISO was informed that the defendant arrived at Second Chance Sober Living, stayed only 2 or 3 days, and then left without notifying staff. That the defendant's then current whereabouts were unknown, as alleged by Mr. Ketley from Community Corrections. What are your client's intentions regarding this allegation, Mr. Watts?
Your Honor, I spoke with my client regarding the allegation. He would agree that he did, in fact, leave the Second Chance Sober Living and not continue to stay in contact with his probation officer. He would stipulate to the violations and waive hearing on that matter.
Very well. Mr. Leal?
Yes.
You heard what your attorney's announcement. I just want to make sure you're aware that you are entitled to a due process hearing where the state would have the obligation of proving this allegation by preponderance of the evidence. You could challenge the state's evidence, present your own evidence, confront the state's witnesses unless good cause was shown. And again, I need to point out to you that among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, sir.
Do you waive a hearing in this case and stipulate and agree that you committed the walkaway without permission from the Sober Living Center and essentially not reporting for a certain period of time?
Yes.
All right. Court finds that the defendant has knowingly waived his right to a hearing, stipulates and agrees that he committed the violation as alleged in the warrant to show cause, which the court read off earlier. This is a substantial and material violation of the terms and conditions of Mr. Leal's probation. He was sentenced back in August of 2025 on a primary crime of possession of fentanyl, a level 5 drug felony, and received a 17-month DOC sentence. It was Senate Bill 123 mandatory at that time. We'll turn to disposition. What is recommended by the state here?
Your Honor, the state would be recommending that the defendant do 3 days in the county jail as a sanction, and we need to get the graduated sanctions started regarding this defendant. And he needs to obviously do treatment, and the probation was for 18 months. So at this juncture, I don't think he needs an extension. But with all previous and standard conditions, court will also need to address court-appointed attorney's fees and the bids application fee.
Mr. Ketley, do you agree that an extension is not necessary at this time?
That is correct. And I have also other stuff but I'll wait until you're ready for my recommendation.
I'll go ahead and take them now.
He has, they completed his Senate Bill 123 evaluation while he's in custody. And he is set to go into Cherry Creek on June 30th. They're going to come and pick him up at the jail at 9 in the morning.
Does he have other holds on him?
I don't believe so.
All right, Mr. Watts, your recommendations regarding an appropriate disposition?
Your Honor, my information from my client is the same, that he has a bed date at Cherry Creek on June 30. That was after an evaluation by SAC. I didn't realize that was done through as part of the Senate Bill 123 process. Sounds like it was. I understand the state's recommendations. I also understand there have to be this dip that has to be done. So I have no objection to the state's recommendations to resolving the dip requirement and then releasing him to treatment at Cherry Creek.
Problem is, counsel, that the timing doesn't work. The dip sanction would only be for 72 hours and he would be released prior to the pickup to go to this Cherry Creek facility. So either I hold him until that point and it doesn't count as a dip sanction because it would exceed the length that a dip sanction is allowed to, or we release him a little bit early and I guess what? He reports to the jail and gets picked up from there on the 30th, since that's where they've been directed to pick him up. How do we work this out? Ms. Norris, your suggestion?
Your Honor, I'm not really sure how we manage it. I know that they made the arrangements for him to be picked up directly from the jail. But I don't know if they can ask them about moving it up a day, but yes, the timing does not quite work out, but I do think that the 3 days is appropriate. And like I said, we do have to start the graduated sanctions process. And, you know, I think, I'm not sure 2 days is going to be any better than 3 days. And I don't know whether or not they can just pick him up from community corrections office or I don't know. I don't know that there's a good way to manage this.
Okay. Thank you. And I understand the quandary that we're in. Mr. Ketley, do you have a suggestion?
You know, Your Honor, I guess my opinion would be that we've already taken off once, and they've already set to come and get him Tuesday. So rather than doing a 3-day sanction, I would recommend he be held until 9 o'clock on the 30th. And if we need to do a sanction, we can try to do a sanction later.
So Leo, do you have anything you wish to state to the court in mitigation of punishment here?
I was just wondering, if I have to do a 72-hour sanction, I was just wondering, because I've been here a couple months, I just didn't know if that counted or.
Nope.
Okay.
And I'll tell you why, because the sanction is ordered today and it's prospective. In other words, it follows court.
Okay.
Any time that you've done previously will be credited to your overall sentence, but not to your dip sanction time.
All right, I was just wondering.
Okay. Plus, I want to make a point here, Mr. Leal. You qualified for Senate Bill 123, and we refer to it as mandatory for Senate Bill 123. Do you know what mandatory means? It means you have to do it.
Yeah.
Have to do it. It isn't an optional part of your sentence. It's a mandatory part of your sentence. It's what keeps you out of prison. So you have to do treatment or you do the prison time. I mean, those are your choices. Because be successful on probation with treatment as a component, or go do the prison time. And if you'd rather go do the prison time, I think the court might accommodate that. But I would think you would want an opportunity to be successful in the community first. Do you?
Yes, I do.
Well, then you can't walk away from a treatment facility, Mr. Leal. I think Mr. Ketley's recommendation, though it's problematic in the view of the court, is the most sound under the circumstances. This court is going to order that Mr. Leal remain in custody until he's picked up by the Cherry Creek facility. And it is thought that they're going to come by Tuesday morning, but if there's a delay, Mr. Leal remains in custody up to 60 days. He can be released anytime starting Tuesday that they pick him up. But again, if there's any delays in their ability to pick him up, he stays in jail until he is picked up. And I do realize by making this order, it's not a graduated sanction under the rules. But I agree with Mr. Ketley. I think it's more important that Mr. Leal remain in custody, remain available for pickup as scheduled. And I think right now, getting him into a treatment program is absolutely the highest priority. And then Mr. Leal, you can't walk away from this one, because walking away from it this time probably means you go to prison. You understand?
Yes.
Okay. You're getting another break. You're getting a considerable break here. Things could be so much worse for you right now. But again, I think everyone on this meeting wants you to successfully complete treatment, but you're going to have to want that and you're going to have to work it. Good luck. I hope you're successful there, Mr. Leal. The court's going to waive additional fees due to Mr. Leal's current circumstances. Incarcerated, then go into treatment. I don't see that he's got the resources to pay additional amounts. At this time, his probation will not need to be extended, but it's still out there for the original period that was established by the court. Ms. Norris, do you need any further clarification regarding the court's orders?
No, Your Honor, thank you.
Mr. Watts, anything further from your perspective?
No, Your Honor, thank you.
Mr. Ketley, do you need any clarification?
I do not, Your Honor.
Okay. I'm sure Mr. Ketley will visit with you about this at some point, Mr. Leal, but you'll need to make sure that you stay in contact with community corrections. When you are released from that facility, Mr. Ketley is going to need to know about it immediately and know exactly what your status is going to be at that point.
I understand.
All right. If there's nothing further, then Mr. Leal will be remanded back to custody until he's picked up by the treatment facility, hopefully Tuesday of next week. All right.
Your Honor, what was the name of that treatment facility? Terry Creek?
Cherry Creek.
Cherry Creek. And they are out of what city?
They're out of Wichita. They're at East Colonial, Wichita.
Okay.
And I did email just for the court's information. I did email them this morning just to check, and they are going to pick him up at 9 o'clock on Tuesday.
Excellent. That's consistent with the view of the court. There's nothing further, then the Christian Leal matter will be in recess. We'll move on to another matter on the dock. Are you ready to present on another case, Mr. Watts?
Judge, I understand Mr. Holt is at court security. I'll need to speak with him. As I do that, however, I do an inquiry as to a Tanya Henry. I show a Tanya Henry on my docket this afternoon. She is not in custody at the jail. Is she somewhere at court security?
She is not at court security, Mr. Watts.
Let's take up the Henry case then. This is State of Kansas versus Tanya Henry. It's case number 2025 CR 121. James Watts appears as defense counsel, Amber Norris for the state. Docket notes indicate that the defendant appeared before Pro Tem Judge Hutchison on the 20th of May. She appeared from the jail in Butler County at that time. The violations were read to her, and a warrant to show cause hearing was set in this court June 26 at 2:30 p.m. by Zoom. She was directed if bond was made, she needed to appear at the Judicial Center, which is the standard for these cases. Mr. Watts was reappointed. I do have the $2,500 surety bond through Butler County Bail Bonds. The theirs does say June 26 at 2:30 p.m. It's now 3:06 p.m. We haven't heard from Ms. Henry. She's not at court security Zoom location at the Judicial Center as she was ordered to be. And I trust you don't have an explanation, Mr. Watts.
I do not, Your Honor. I've had no contact with her.
Court finds that this is a failure to appear that's unexcused. Court will issue an order of bond forfeiture, a bench warrant issue for Tanya Henry's arrest, and she is to be held on a no bond hold pending further proceedings in relation to this matter. With that order made, I think that disposes of the Henry case on this docket. We're going to take a brief recess then, a pause at least in proceedings to allow Mr. Watts to confer with Kevin Holt.
Your Honor, that's my last case. Can I be excused?
That
was me.
Okay. Who is on the Holt case?
It's Christie.
Okay, very good. Thank you.
Right.
Appreciate it, Mr. Ketley.
Thank you.
All right. Kevin Holt. Kevin?
Yeah.
Okay. We can go ahead and resume proceedings on the docket at this time with the case of State of Kansas versus Kevin Scott Holt. It's case number 2023 CR 470. Brett Sweeney appears for the State of Kansas. James Watts is defense counsel. Kevin Holt appears at the court security Zoom location. This matter comes before the court at this time for review of probation. The violations alleged in this case by Ms. Ashenfelter from Community Corrections is that in May, the defendant admitted to methamphetamine use. And then on April 19, alleging that he was evicted from the Second Chance Sober Living House. Mr. Watts, what are your client's intentions regarding these allegations?
Your Honor, I've discussed the matter with my client on the warrant to show cause. He would acknowledge that he admitted to methamphetamine use on May 4, that he was evicted from the Second Chance Sober Living House on April 19, and waive hearing on those matters. I would note, because I know Mr. Sweeney will point it out, there is an addendum to that original warrant, which alleges using methamphetamine on May 26 and unsuccessfully discharged from addiction recovery counseling on June 2nd. He would stipulate to those violations as well and waive hearing.
Very well. Mr. Holt, you've heard your attorney's statements regarding your intention to now waive a hearing and stipulate and agree that you committed the violations not only in the original warrant to show cause, but these additional violations that have been read into the record. Is that indeed your intention?
Yeah, I heard him.
Okay. You understand that you are entitled to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can present your own evidence at such a hearing, challenge the state's evidence with the assistance of your lawyer, confront the state's witnesses unless good cause was shown, and among other lesser remedies, the court could consider that you could be ordered into long-term incarceration as a result of these violations. Do you understand these things?
Yeah.
And do you now waive a hearing and stipulate and agree that you committed the violations that have been outlined here on the record?
Yeah, I waive it.
All right. Court finds that the defendant has knowingly waived a hearing in the case and therefore stipulates and agrees that he committed the violations as alleged. Court finds that these are substantial and material violations of the terms and conditions of Mr. Holt's probation. Mr. Sweeney, what are your recommendations regarding disposition?
Thank you, Your Honor. Your Honor, the state's recommendations in consultation with the ISO who's supervising Mr. Holt are that he do a 60-day jail sanction. He would need an extension of probation. It plays back on after the conclusion of a 60-day jail sanction. And that's as a condition of his continued probation, if the court would adopt that recommendation, that he reside in a sober living house and attend and complete outpatient treatment as is required through his Senate Bill 123 treatment.
Okay, I'm going to turn to Ms. Ashenfelter. Does he have a sober living house option available to him at this time?
Yes, Your Honor. There's still a second chance he can go back to here in town.
Okay. And the outpatient program he would then resume or start anew would be what?
Well, he could pick up where he left off if they're willing to take him back after he completes whatever the court orders today.
And that would be with what formal program?
Whichever program he chooses.
Okay. But you believe that he could enter into an outpatient program relatively soon?
Yes.
Okay, thank you for that additional information. All right, Mr. Watts, your recommendations here?
Your Honor, the second part of that recommendation, I would join that following the sanction, he re-enter the treatment program, and I think it can be successful. And we had a long discussion while I was meeting with him about just how important the alternative, and as I lay it out to my clients, the alternative to participating in the treatment program and taking it seriously is that he goes to prison to serve, in this case, 14 months. It has to be the highest priority. And I understand that people have other things in their lives. Those other things simply have to take a back seat to treatment and reporting. That has to be the highest priority at this point. So I would join that part of the recommendation. The first part of it, I think the jail time sanction is maybe well called for. I don't know that 60 days is necessary to do that. I think that a sanction somewhere in the 14 to 30-day range would be sufficient to do that. The most important thing is not that he sit in jail for 2 months accomplishing nothing, but he get himself, although appropriate sanction must be served, they get himself into a treatment program, begin that treatment program as soon as possible and get it finished and completed as soon as possible so he can get on with his life.
Does your client have a job currently?
Yes.
Okay, Mr. Holt, can you tell me about that?
I work for Art and Mary, helping him out. We work around him, work with him.
You work for who?
Art and Mary.
Art and Mary Thomason?
Yeah.
Okay. So do you work out at their trailer sales location east of town?
I work pretty much at their house, pretty much.
Okay. How much money do you make doing work for them?
I usually work about $60, $70 a day.
Did you say 50 to 70?
Yeah.
Okay. Is there anything that you wish to state to the court at this time, Mr. Holt, in mitigation of punishment?
I got lots of trying to help my parents out most of the time. My dad's going through a lot of cancer problems and had his foot cut off, and I'm trying to help him out. So, I don't know.
Okay. Anything else, Mr. Holt?
No.
You need to quit doing methamphetamine.
Yeah, I know.
It's a horrible chemical compound, one of the worst compounded, because it ruins people's lives, Mr. Holt.
Yeah.
You need to get off of it. And that's what a treatment program is going to help you do. But you got to successfully complete it, though, too. And you
Yeah.
have to be committed to it. I would suspect that Ms. Ashenfelter has already attempted to do some sort of dip sanctions as part of community corrections. Is that a fair statement?
Yeah.
But the court has not ordered one. And I'm inclined to agree with Mr. Watts in this case. Mr. Holt, do you deserve to go to jail for a long time? Yes, you do. But is that the solution that the court's going to choose today? No, it is not. This court is going to order a 3-day dip sanction effective immediately. I am not aware that there's been a court-ordered dip sanction in this case, and I want to make sure there's one clearly established of record. Because Mr. Holt, I think Mr. Watts, he's so experienced, and I know he's very straight with his clients, but I think you need to understand that at this point, after this dip sanction, and after you go back onto community corrections, if you don't do your treatment, you're going to go to prison. It's one or the other. I don't understand why you choose prison over a treatment program. I'm sure treatment programs aren't that fun, but they are meant to be beneficial to you. So you have to complete it. Because if you come back before the court again with, I think, a horrific record on probation that was presented today, it would show the court that you're not really committed to sobriety. You're not committed to the treatment program, which you're supposed to be in. And then the alternative then is for this court to just have you do your prison time.
Okay.
So the court's going to order Mr. Holt into custody for a period of 72 consecutive hours without release privileges, then to be released back onto community corrections with any previously established condition remaining, including a specific directive that he promptly enter into a sober living house and re-engage successfully in outpatient substance abuse treatment.
Sure.
Now, you caught a break today, Mr. Holt. In fact, you've caught several breaks along the way, but you're just about out of them.
Okay.
Okay. I really want to see you be successful and get off methamphetamine so that you can have a normal life. And I don't know who you're associating with to get meth in, but that's a dangerous game to be playing, Mr. Holt.
Yeah.
And you do have a job. I am going to assess some additional fees to you at this time. How much are your fees for this round of representation, Mr. Watts?
Oh, Judge, show cause is billed at, I think it's $800 if I remember.
All right. All right. I'm going to assess about 3 days worth of his pay at $70 a day. I'm going to assess $210 in additional legal fees. Waive the bids application fee, but add that $210 to his existing balance, whatever it might be. And of course, that needs to be paid off here in due course. Is he on a payment plan, Christy? He's supposed to be paying $100 a month.
Your Honor, his court costs are already paid.
Okay. Well, you've got 60 days to pay this amount, Mr. Holt, this additional $210. At the end of that 60 days, it can be referred to collections. At that point, it becomes immediately due, payable, and collectible. But I will give you a 60-day grace period to get it paid.
Okay.
Sooner the better.
Okay.
All right. Extension. Let's look at that. Ms. Ashenfelter, what is your view regarding whether an extension is necessary or not?
Your Honor, originally I thought he would need an extension, but his case doesn't expire until November. So if he completes the 3 days, gets out, gets started on everything, my hope for him is that he'll just be done before that time or by that time.
I appreciate your optimistic view, and I hope the defendant, Mr. Holt, shares it. All right. At this time, no extension will be ordered. I just want to state for the record that he appears to be on probation until November the 9th of the year 2026. consistent with the 18 months ordered on May 9 of 2025. And I trust there's no disagreement with that computation.
No.
Okay. Mr. Sweeney, anything else that the court needs to address regarding Mr. Holt?
No, Your Honor, thank you.
Mr. Watts, anything further at this time?
Nothing else, Your Honor. Thank you.
All right. I'm going to place Mr. Holt in the custody of the Butler County Sheriff's representatives so that he can be taken to the jail at this time to serve 72 consecutive hours sanction time, quick dip time, without any release privileges. He'll be released 3 days from now.
Okay.
There's nothing further then. The Kevin Scott Holt matter will be in recess.
You good. Put your hat on.
All right. Mr. Sweeney, this would appear to bring us to the end of this docket. Would you agree with that?
I would, Your Honor, thank you.
Mr. Watts, thank you for your appearance here this afternoon. There's nothing further. And the partnership docket at this time is considered concluded. The court is in recess. The meeting.
I love Judge Ricky. So, in Kansas, they have the Senate Bill 123 rehab program, essentially. Typically, if it's like your first drug offense or your first handful of them, they'll put you on the Senate Bill 123 program in an effort to get you treatment instead of jail. So it's just a more drug-related testing probation, basically. When you're on that, if you violate, your first violation is considered a dip, which is typically 2 days. I'm surprised he did 3 days here because 3 days is usually the second violation, and they call that a dunk. And then the next, so it's 2 days dip, 3 days dunk, and then the third time you violate, it's like a weekend, and I don't remember what they call that. Uh-oh. Earl has entered. Bandit's going to lose her crap. But yeah, that's all that it is it's just the graduated step up sanctioning program that they have when they have offenders on that. It's okay, baby. You know, I love Earl too, you know. All right, guys. I'm gonna have to take Bandit back to her room now, so I'm going to let you guys go for the night. Let me put my PAWFURM banner back up, otherwise I'll forget to do that next time. Thank you guys for coming and hanging out with me. I'm glad you guys got to meet Bandit. Probably be with him for the rest of his life. And that's scary. He probably has, you know, some permanent damage done to his brain. You don't know what's in that stuff. You never know. It's not like it's made in a facility. You know, Earl, you're not helping. Thank you guys so much. Stop. Go. Be safe, be well, sleep sweet, and much love.